Let's talk about ways at trial or in deposition or points in litigation when attorneys might be able to destroy witness credibility. Most of the time, what this is referred to is impeachment. And that's often the purpose of taking a deposition, is that what we're doing is, in part, in taking a deposition, is locking in defendants' statements and locking in what their testimony will be at trial. Very often, when we go to trial, there aren't a lot of surprises. So strategies and presentation might be a surprise, but the content of people's testimony isn't often a surprise. We've secured these depositions. We know what people are going to say. So in order to impeach their credibility, we may ask similar questions or the same questions as what was asked in a prior deposition, and then demonstrate that their testimony is inconsistent from those statements. We can also, in a deposition, look at prior statements that may be given to an insurance company or witness statements that have been given in other contexts. And when we ask those questions in a deposition, similarly, we're looking towards these unsworn testimony to say, well, why did you make this statement here? Maybe there's a statement in a crash report. This is not what you told a police officer at the scene, was it? And then showing that the statements that they're giving in the deposition are actually inconsistent. That's a very common method, using prior inconsistent statements in order to impeach a witness's credibility. They work slightly different in a deposition versus at trial, because a deposition is sworn testimony. You're under the penalty of perjury if your statements are demonstrated to have been made falsely in a deposition. So that's certainly a strong way that you can destroy witness credibility. Another might be bias or some sort of motive to lie. We can show that somebody may have some sort of an interest in the case or relationship to a witness. This happens oftentimes in expert depositions, where we can show that an expert may have an existing relationship with the opposing counsel. That opposing counsel has worked with that expert many times before. Maybe they've even been at social functions together, gone golfing together. So they may have some sort of motivation or bias that shows that their testimony might not be exactly neutral. Maybe they don't actually have personal knowledge of a witness might have personal knowledge of a situation. They just heard this from somebody else. This is a hearsay objection to witness testimony. You're telling us this, making the statement to us as if it's true, but this is actually something that you heard from somebody else or was written somewhere else. This is not actually something you have personal knowledge of. And sometimes we may look at somebody's credibility just by nature of their past acts, their character. There's a kind of character impeachment that you can present in a trial or a deposition. Maybe somebody has convictions. We are often looking to see if somebody's been convicted of crimes of moral turpitude, which essentially means crimes of dishonesty. It might be theft or fraud or prior felonies that may show that this person has a propensity to lie or commit criminal conduct. And we can use that in order to destroy a witness's credibility. You know, you've clearly demonstrated a pattern of past convictions. Why would your presentation today of how this crash occurred be accurate when you've been convicted of similar incidents of fraud or theft in the past? So there are a variety of different methods that we can use, and they all fall under different rules of evidence and rules of civil procedure. But a competent attorney will have knowledge of all of those methods and deploy them effectively at both depositions and at trial in order to effectively litigate your case.